चेक चेक, आवाज आ रही है? ये इसकी आवाज। मैंने ये
हम सुन पहले ही से ज्वाइन हो रहे क्या आप? हाँ।
अच्छा 30 वाली वेरी गुड। सारे थोड़ी को लोग इधर वाले इधर तो कोई भी कोई भी मत। सुशीला मैम, आपका माइक ऑन है, एक बार ऑफ कर दीजिए प्लीज।
मेरा तो म्यूट है अब। अच्छा
मैम इट इज रिक्वेस्टेड दैट नो मैसेज में भी सेंड कोई मैसेज ना भेजें प्लीज अभी.
Good evening and namaskar to everyone. I advocate Anu Singh. On behalf of Adhivakta Parishad Delhi Pran, welcome you all to the final round of 4th National Virtual Criminal Moot Court Competition. We extend a warm and a respectful welcome to our esteemed judges, whose presence lends great honor to the moot court. We also congratulate all the team who had made it this far and commend their dedication, preparation, and perseverance. Today marks the conclusion of rigorous research, disciplined preparation, and passionate advocacy. This final round is not merely about winning, but about demonstrating clarity of thoughts, respect of the law, and confidence at the bar. To all the finalists present here today, this courtroom is your training ground, and this moment is a significant milestone in your legal journey. Now, I would like to invite Sri Jivesh ji, who is the Central Government Standing Counsel for Union of India, and our former General Secretary Adhivakta Parishad, Delhi Pran, for the welcome speech.
नमस्कार सबको. I heartily welcome our Chief Guest Justice Anil Chetrapal ji, Shri S.D. Sanjay ji, ASG, Senior Advocate Balbir Singh ji, and हमारे दिल्ली प्रांत के President Sanjay Podaji, Senior Advocate, and all the other my team members and dignitaries who are there. It's my honor कि आज हम virtual online 4th national moot court कर रहे हैं. और ये हमारा सौभाग्य रहा है कि कोविड में जब कोविड काल शुरू हुआ था तो हमने फर्स्ट टाइम ये ऑनलाइन मूट कोर्ट किया था. दैट वाज इन 2020. और उसके बाद से 2021, 22 एंड देन दिस ईयर वी आर हैविंग अ नेशनल क्रिमिनल मूट कोर्ट. थोड़ा सा मैं ब्रीफ बैकग्राउंड आई वुड लाइक टू शेयर विद ऑल ऑफ यू. ये हमारा एक नेशनल क्रिमिनल मूट कोर्ट कंपटीशन है इस साल और अराउंड 95 टीम्स फ्रॉम ऑल ओवर द इंडिया ने रजिस्टर किया था इसमें, जिसमें से 58 टीम्स वे शॉर्टलिस्टेड. एंड देन वी हैड अभी तक वी हैड अराउंड 29 कोर्ट्स जिसमें प्री क्वार्टर हुए थे हमारे 8 कोर्ट्स के, फिर क्वार्टर्स, सेमीज, एंड टुडे वी आर हियर फॉर द फाइनल्स, जिसमें हमारी 2 टीम्स हैं, ऑल टीम्स फ्रॉम ऑल ओवर द इंडिया, राइट फ्रॉम नॉर्थ से, नॉर्थ ईस्ट से, आसाम से, साउथ से, तमिलनाडु से लेके वेस्ट ईस्ट, ऑल हैव बीन पार्टिसिपेटिंग। अराउंड 100 एडवोकेट्स हमारे इस पूरे इस ऑर्गेनाइज करने में इसको लगे हुए थे। And we had semi-finals में we had judges also from all parts of the country. In the semi-finals, we had a justice from Odisha High Court, and in the other semi-final, we had justice from the Allahabad High Court. And in the finals, of course, we have our own Justice Chetrapal here presiding over this. Moot court is a very, हम सबको पता ही है, now with this passage of time, it's a very exciting experience for the young advocates, would-be advocates, to be a part of this, to be in a court before the court. It's an experience to be, and I hope all the teams who have been, including quite NLUs, where काफी participate किए थे. So I hope all the teams who have been here, who have been putting their hard work, and today is the day of the finals. I give them my best wishes that they go अच्छा करें. With this, I rest my words. Thanks.
Thank you, sir, for walking us through a hard work of organizing committee Delhi Prant. We are deeply honored to have with us a distinguished panel of judges for the final round, whose presence truly elevates today's proceedings. In a matter of great honor and privilege for us to have with us today Honorable Justice Anil Chetrapalji, Judge Delhi High Court. Sir hails Kurukshetra, where his journey in law begins with his enrollment at the bar in 1987. In 1991, Sir began his independent practice, specializing in civil and constitutional matters, areas central to the rule of law and justice in the democracy. His dedication and professional excellence were recognized in January 2014, when he was designated as a senior advocate by Punjab and Haryana High Court. On 10 July 2017, he was elevated as an additional judge of Punjab and Haryana High Court, and later confirmed as a permanent judge in December 2018. Most recently, he took oath as a judge of Delhi High Court on 21st July 2025, after being transferred from the Punjab and Haryana Court, bringing with him decades judicial experiences and deep commitment to the legal excellence. Today, we are privileged to have Justice Chetrapal presiding over this Moot court finale. We look forward to the wisdom of his observation and the dignity of his presence to our participants present their best arguments. Please join me with welcoming Honorable Justice Sri Anil Chetrapalji. Further, it is my privilege to invite Senior Advocate Sri S.D. Sanjay, who presently serves as the Additional Solicitor General of India before the Honorable Supreme Court of India, who is Distinguished Law Officer of the Union of India, who joined us as a judge for final round of this Moot court competition. Sir represents Union of India in a matter of immense constitutional, administrative, and national importance. As a senior law officer, he exerts the Attorney General and Solicitor General in defending the government's position at the highest judicial forum of the country, a responsibility that demands exceptional legal acumen, integrity, and clarity of thoughts. Prior to his appointment in the Supreme Court, Sir made significant contribution as the Additional Solicitor General in High Court, where he handled complex public law and constitutional matters on behalf of Government of India. His presence here today is not only an honor for this competition, but also a source of inspiration for our budding advocates who aspire to serve the legal profession with the same dedication and distinction. We are truly privileged to have him preside over the final round, and we look forward his guidance and valuable observations. Please join me in giving warm welcome to Senior Advocates and Additional Solicitor General of India, Shri S.D. Sanjay ji. And now, with immense pleasure and deep sense of honor, to introduce a distinguished member of the bar, Senior Advocate Shri Balbir Singh ji, former ASG Supreme Court. Mr. Singh is a legal luminary whose career reflects excellence in advocacy, depth of legal reasoning, and unwavering commitment to the rule of law. Designation as a senior advocate is one of the highest recognition at the bar, reserved for those who have demonstrated outstanding ability, integrity, and contribution to the development of law. Mr. Singh truly exemplifies these qualities. Over the year, Mr. Singh has appeared in numerous complex and significant matters where his clarity of thought, structured argument, and command over legal principles have earned him immense respect from both the bench and the bar. Beyond this courtroom excellence, Mr. Singh has a source of guidance and inspiration for young lawyers, constantly emphasizing preparation, ethics, and responsibility as the cornerstones of the successful advocacy. His presence here today offers and participants a valuable opportunity to learn from practitioner who embodies the highest standard of the profession. We are truly privileged to have him preside over the final round, and we look forward to his insightful observation and guidance. Please join me in warming welcome Senior Advocate Shri Balveer Singh Ji. With this now, move towards the most awaited segment of the day, the final round of the 4th National Virtual Criminal Moot Court Competition. Now, I invite the Court Master, Mr. Adit Deshwal, to please take over.
Thank you, ma'am. With the permission of the honorable judges, may I briefly read out the rules for the final round for the notice of the participants.
Please do, sir.
Please. During the course of oral submissions, no speaker shall reveal his or the identity of his or her college. In such eventuality, that team shall be marked negatively as deemed appropriate by the judges. Each team shall have maximum of 45 minutes to present their oral submissions. At the commencement of each session of oral submissions, each team must notify the court the time duration that the team wants to reserve for rejoinder or sur rejoinder. A maximum of 5 minutes can be reserved for rejoinder or sur rejoinder. No speaker will be permitted to address the honorable court for more than 30 minutes. At the commencement of each session, the team before starting oral submissions shall notify the honorable court the division of time between their two speakers. 5 minutes and 1 minute before the completion of the allocated time for each speaker, there will be a message in the chat box, and the completion of the allocated time for each speaker, there will be a final message. If any speaker continues to speak after the completion of his or her time, the additional time which he or she speaks for will be deducted from the time allocated to his or her co-speaker, or from the time allocated for the rejoinder and sur rejoinder, as the case shall be. Honorable judges at their discretion may extend oral arguments time up to a maximum of 10 minutes per team. Now, with the permission of the honorable court, may I request the team appellant having team code 574 to indicate the time which their respective speakers will take for their oral submissions.
Court Master, from team 574, speaker 1 will take 21 minutes. Speaker 2 will take 20 minutes, and 4 minutes we will keep reserved for the rejoinder.
Now I request team 547, team for respondent, to indicate their time which their respective speakers will take for oral submissions.
Court Master, the speaker number 1 will be taking 22 minutes. Speaker number 2 will take 18 minutes, and we will be reserving 5 minutes for sur rejoinder.
Now I request the team appellant to start their oral submission with the permission of the honorable judges.
Please do.
Greetings to the honorable bench. If the honorable bench is well versed with the facts of the case, the counsel seeks permission to proceed with the statement of facts. If may not, the counsel seeks permission with the statement of the
I think you can straightway come to your submissions because we have already read that file.
Much obliged, Your Lordship.
Right?
Your Lordship, in the present case, there are the 4 issues, and I will be dealing issue number 1 and 2, and my co-counsel will be dealing issue number 3 and 4. Your Lordship, the issue number 1 in the present case is whether the conviction under section 103 of the Bharatiya Nyaya Sanhita is sustainable in the absence of intention or knowledge. May it please before this honorable court. I am appearing on the behalf of the appellant, Mr. Sumit Khanna. Your Lordship, the important question before this court is whether a conviction for murder under Section 103 of the BNS can be sustained when the prosecution has failed to establish intention or knowledge which form the very soul of the offense of the murder. Your Lordship, this issue is basically arranged in a basically three sub-issue, and I will be dealing each of the sub-issue one by one. Your Lordship, now coming on the first sub-issue of issue number one is absence of premeditated intention or knowledge. Your Lordship, a conviction for murder under section. Shall I continue, Your Lordship?
Yes, yes, please continue, sir.
Your Lordship, a conviction for murder under Section 103 of the BNS cannot rest merely on the occurrence of death. Your Lordship, the prosecution must prove beyond a reasonable doubt the presence of a specific mental element, intention to cause death or knowledge that the act was likely to cause death. Your Lordship, may I draw the attention of the Honorable Bench on a landmark case of Birsa Singh versus State of Punjab, AIR 1958, Supreme Court 465. In this case, the Honorable Supreme Court held that intention cannot be inferred from the fatal consequences alone. It must be accompanied the act as a conscious, deliberate state of mind. Your Lordship, if we go to the factual matrix of the case, TW1, that is the prosecution witness, confirms that the appellant was moving backward while the JCB advanced, and the repeated discharge the moment he lost the balance, Your Lordship. There was no deliberate aiming, no repeated firing, and no prior hostility, and only one shot was discharged from the weapon, Your Lordship. The deceased was barely operating the JCB and had no involvement in the ongoing land dispute. Such circumstances are inconsistent with a premeditated act of homicide, Your Lordship. Your Lordship, the court has repeatedly held that sudden confrontation without pre-planning cannot orderly be elevated to murder. Your Lordship, the Honorable Supreme Court in a pattern of the judgment like State of Andhra Pradesh versus Rayavarapu Punaya, the case citation is 19644 SEC 382 and Kandaswamy versus State of Tamil Nadu 2008 Supreme Court and Jagdish versus State of Rajasthan. Your Lordship supported my argument, and Your Lordship, the chemical analyzer report that is mentioned from the page number 19 to 25 of the Moot prop clearly stated that there was no close range firing residue and only a single deflected shot was fired. Your Lordship, applying the test laid down in the case of a very landmark case, the Sharad Birdichan Sharda versus State of Maharashtra, AIR 1984, Supreme Court 1622, which mandates that the chain of circumstances must be so complete as to exclude every other reasonable possibility except the guilt of the accused, Your Lordship. And Your Lordship, in the present case, the chain of circumstances does not completed, Your Lordship. And Your Lordship, in the case of Arvind Kumar versus State of NCT of Delhi, 2023, INSC 622, the Honorable Supreme Court held that the accidental fire discharge under instability cannot sustain murder liability, Your Lordship. Here the essential mens rea is absent. And the conviction under Section 103 BNS cannot stand, Your Lordship. Your Lordship, the prosecution may contend that the alleged verbal threats attract Section 351 of the BNS, Your Lordship. But, Your Lordship, in the case of Vikram Johar versus State of Uttar Pradesh, 2019, INSC 583, the Honorable Supreme Court held that the use of abusive words in an aggression does not constitute criminal intimidation under Section 503, 506 IPC, which is pari to 351 BNS. Thus, such utterance private defense, Your Lordship. Your Lordship, even assuming for the sake of argument, the Appellant Act caused death, criminal law does not punish every act that result in death. Your Lordship, the present case squarely fall within the statutory protection under Section 18 and 38 of the Bharatiya Nyaya Sanhita 2023. Your Lordship, according to the Section 18 BNS exempts act done by accident or misfortune without criminal intention or knowledge while performing a lawful act with due care and caution. Here the appellant was standing on his own land, confronted with an advancing JCB and was retreating solely to avoid imminent bodily harm when the firearm accidentally discharged. Your Lordship, the FIR and the charge sheet confirms that JCB was moved towards the appellant on PW1 inspection, creating a sudden threatening situation, Your Lordship. The discharge occurred during retreat, not as an act of aggression, Your Lordship. Your Lordship, in the case of Kurban Hussain versus State of Maharashtra, all AIR 1965, Supreme Court 1616. The court held that where the mental element is not connected to the harmful consequence, criminal liability cannot attach, Your Lordship. Independently, the circumstances attract the statutory right of private defense under Section 38 of the Bharatiya Nyaya Sanhita, Your Lordship. The advancing JCB created a reasonable apprehension of grievous harm, Your Lordship, and the Honorable Supreme Court in the category of the judgment like Darshan Singh versus State of Punjab, and further reiterated in the cases of Munshi Ram versus Delhi administration, Vishwanath versus State of UP, Jagdish versus State of Rajasthan, that a person faced with imminent danger is not expected to modulate his defense in a golden scale. Accordingly, the Appellate Act fall within the protective ambit of accident and private defense, rendering the conviction under Section 103 BNS legally unsustainable, and benefit of general exception must be given to him, Your Lordship. Now, coming on the third submission of the issue number 1, Your Lordship, the misapplication of Section 103 of the Bharatiya Nyaya Sanhita. Your Lordship, the conviction cannot, because the Section 103 has been invoked in a mechanical manner without satisfying its core mental element requirement of intention or knowledge. Your Lordship, may I draw the attention of an honorable bench on a very landmark case of Supreme Court, Pulli Chherla Nagarju versus State of Andhra Pradesh, 2006, 11, SCC 444. The Honorable Court laid down a decisive indicators for inferring intention in homicide cases, like the nature of weapon use, the part of body targeted, and degree of force applied, the existence of prior enmity or motive, and whether the act consisted of a single blow or repeated assault. Tested on these parameters, the prosecution feels at every stage there was no deliberating target of a vital part and no repetition of firing, no prior hostility or motive, no close range discharge, and the deceased was a stranger with the incident involving a single instantaneous discharge during the appellate lost the balance. Your Lordship, the court has consistently held in a case of State of Rajasthan versus Kanhaiya Lal, Ramesh Kumar versus State and City of Delhi, and Arun Kumar versus State and City of Delhi, that a solitary act in a certain situation, absent motive or targeting, cannot justify an inference of intention, Your Lordship. And Your Lordship, may I draw the attention of our honorable bench on a case of Kali Ram versus Himachal Pradesh, 1973 to SCC 808. Your Lordship, in this case, it was held that if two views are possible and one favoring the accused innocence, that must be prevailed, Your Lordship. On this fact, Your Lordship, the present case fall outside the ambit of Section 103, Your Lordship. The .32 revolver involved in a non-prohibited arm under the Arms Act 1959. Therefore, Your Lordship, Section 7 and Section 27 Clause 3 are wholly inapplicable. The appellant was the lawful position, Your Lordship. Now, coming on the issue number 2, Your Lordship. Your Lordship, the issue number 2 is whether the alleged firing by the accused number 1 fall within the general exception of accident or misfortune under Section 18 of the Bharatiya Nyaya Sanhita 2023. Your Lordship, may it please before this honorable court, the appellant respectfully submit that the alleged firing squarely fall within the general exception of accident or misfortune under Section 18 of the BNS, and therefore no criminal liability for murder under Section 103 can be sustained. Your Lordship, Section 18 of the BNS expressly protect an act done in an accident or misfortune without criminal intention or knowledge while performing a lawful act with due care and caution. And the present case falls squarely within this protection. The firing did not arise from any conscious or voluntary decision to cause harm. Rather, the record, Your Lordship, itself established that it occurred as an involuntary reaction triggered by a loss of balance in a sudden threatening situation, Your Lordship. The FIR, Your Lordship, and PW1 statement confirm that the JCB was moved forward on this section to break the fencing, compelling the appellant to step back to avoid imminent contact. It was during this retreat, Your Lordship, the firearm discharged significantly. The charge sheet does not allege any advanced movement, repeated firing, or deliberate aiming by the appellant, which clearly rules out any intention, Your Lordship. Your Lordship, the Supreme Court in the case of State of Odisha versus Khoragasi, 1979, 1 SCC 568 has categorically held that When a firearm goes off accidentally due to a fall or sudden movement, and intention is not proved, the defense of accident must be extended as criminal liability cannot arise in the absence of a conscious decision to pull the trigger, Your Lordship. That principle applies with full force here in the present case, Your Lordship. Further, Your Lordship, the site plan that is mentioned on the page number 30 of the Moot proposition and seizure memo corroborate the close proximity of the GCB to the appellant, placing him in an unstable and defensive position. And it is undisputed that only a single shot was fired without no reloading and no repeated firing, Your Lordship. Your Lordship, in the case of Kurban Hussain versus State of Maharashtra, TIR 1965, Supreme Court 1616. It was held that criminal culpability requires a conscious nexus between mental element and the act, and where the result flows from an unintended accident, the element of guilt is absent. Accordingly, the essential requirement of the mens rea under BNS is not satisfied. Now, coming on the second sub-issue of issue number 2, reasonable defensive conduct in a sudden and a threatening situation, Your Lordship. The factual records of the case establish that the situation at the site was sudden, rapidly escalating, and physically threatening. And Your Lordship, the PW1 admits that he instructed the GCB operator to break the fencing, which escalated the situation, and GCB was moved forward towards the appellant. And Your Lordship, DW1 confirms that the appellant was compelled to retreat to avoid being struck, and it was during the defensive movement that he lost the balance and the firearm discharge. And Your Lordship, this statement was basically admissible in the trial court also as per the page number 43 of the Moot prop, Your Lordship. Your Lordship, more recently, Your Lordship, in the case of Nandu Manilal Mudalilal versus State of Gujarat, it's a very recent case of the Honorable Supreme Court of year 2025. The case citation is INS 2025 INSC 1302 and Mohammad Hassan versus State of Haryana 2024 INSC 338. The court emphasizes that the defensive conduct must be judged in the light of the surrounding circumstances confronting the accused, Your Lordship. Now, coming on the third sub-issue of the Lordship, the absence of premeditation, motive, or prior hostility, Your Lordship. The prosecution has completely failed to establish any reason why the appellant would intended to cause the death of a deceased who was merely a contractual JCB operator with no prior interaction, hostility, or animus towards the appellant. The dispute at the site was purely a civil and property related involving PW1 alone. Your Lordship, may I draw the attention of the Honorable Bench on a case of Sukhdev Singh versus State of Haryana, 2013 to SCC 212. The absence of prior hostility and motive in a sudden confrontation significantly weaken any inference of intention, Your Lordship. And similarly, Your Lordship, the Honorable Supreme Court in the case of Surinder Kumar versus Union Territory Chandigarh, 1989 to SCC 217, the court emphasized that where the intention is inferred circumstantially, the lack of motive imposes a heavier burden on the prosecution, a burden that remains wholly unfilled here, Your Lordship. Your Lordship, as I have already mentioned in the case of Arvind Kumar versus State and City of Delhi, it was held that a single act during sudden movement without prior enmity or targeting cannot establish intention merely from the fatal result, Your Lordship. This is reinforced by the chemical analyzer report, Your Lordship, that is mentioned from the page 19 to 25, chemical analyzer report number 1 and 2, Your Lordship, as per the factual matrix of the case, which confirms that bullets first struck the JCB windshield, showing the deceased were not intended targets, as reiterated by in the case of Bhutto Ram versus State of Himachal Pradesh. It was held that the court held that the absence of motive and pre-planning decisively rules out murder. In view of the foregoing submission, the alleged firing was accident without intention or knowledge and occurred during a sudden and a defensive retreat. The essential mens rea under Section 103 BNS is absent, while the statutory requirement of Section 18 BNS stands fully satisfied. Accordingly, the appellant is entitled to the benefit of general exception, and the conviction for murder is unsustainable in law. Your Lordship, if the Honorable Bench having any further question, they can ask. If not, the Council seeks permission to. Yes, indeed.
Can I put your question, sir? Please tell me.
Yes.
It's not in dispute that the appellant number 1 had a loaded revolver in his possession when he came to the site. How do you explain that?
Your Lordship, Mr. Appellant was having a valid license, and it is not wrong to, if you are having a valid license, you can carry away
The
a gun.
valid, it may be a licensed weapon, but loaded revolver, he came with a loaded revolver at the site.
Your Lordship, if someone is having a license, then it will not carry just without bullets, Your Lordship.
All right.
And Your Lordship, and one more thing I just want to add. There was 4 cartridges in the revolver, and out of only 1 he shot, and 3 was still there, and he did not even try to escape from that place, Your Lordship. If he planned to murder someone, then why he remain at that place, Your Lordship, after the killing someone?
There is a question. May I?
Yes.
You have just referred section 18 of Bharatiya Nyaya Sanhita, now which says accident in doing a lawful act. Now, just now, my lords have posed a question from you that he came with a loaded revolver. Now, he had come for what lawful act he was doing? If there was any problem that a person was using the JCB on his land, then he could have resorted to informing the police that he is forcibly doing some act on my land instead of taking law in his own hand with the revolver. What is your explanation?
Your Lordship, as per the case, because there was a disputed land and there was basically a civil case was going on that particular in the court, Your Lordship. That was the main reason. And Your Lordship, Mr. Sumit Khanna is not a person who knows. We cannot assume that every person is different, and it's not necessary that we are lawyers so that everyone should know the law. And he just want to protect his land.
I'll just quickly add one more question on the intention and knowledge. Am I?
Indeed.
So, your client knew very well that he is entering into a disputed territory, which means there was already a dispute going on. Loaded carried to. I'm not saying that the licensed weapon cannot be carried to any place. It's not that he's usually going to a place. There is some threat which has been to him. He knew very well that he is going in a space which is disputed. He knew that there is a dispute going on. He knew that the land is to be leveled up. From the intention and the knowledge point of view, is it not sufficient to draw inference that somebody knowing very well that I'm entering into a territory which is going to be a disputed territory, where there's a land dispute going on, and I'm carrying a weapon? Is it not going to add to knowledge and intention?
Your Lordship, for that, I just want to draw your attention on the page number 30, site plan. Mr. Sumit Khanna was standing on his own land, Your Lordship. There was a different plot between, if we go to the site plan that is mentioned on the page number 30 of the case record, Sumit Khanna was standing on his own land, and the JCB, basically the leveling of the field was going on some other means adjacent plot, Your Lordship.
Right, noted.
Thank you.
If the Honorable Bench does not having any further question, the Council seeks permission to call the co-counsel for dealing with the rest of the issues.
Yes, sir. Yes, please do.
Your Lordship, co-counsel seeks permission to approach the court.
Yes, please.
If it may please, the co-counsel seeks permission to address the bench as Your Lordship.
You may address any. You can even address her, sir.
Or possibly,
that is not the issue. You can please proceed with the case, sir.
Much obliged, Your Lordship. Your Lordship, I am dealing with 2 issues, issue number 3 and issue number 4. And basically, issue number 3 states that whether accused number 1 was entitled to the right of private defense of body under Bharatiya Nyaya Sanhita, considering the imminent threat from the JCB machine. It is most humbly submitted that the conviction of accused number 1 under section 103 of Bharatiya Nyaya Sanhita is a grave miscarriage of justice. We contend that his action fall squarely within the protection of section 13 of 13(8) of BNS. The provision is not merely a legal technicality, it's a statutory recognition of the most fundamental human instinct, the instinct of self-preservation. According to section 38, the right of private defense extends to the voluntary causing of death, if the assault reasonably causes an apprehension of death or grievous hurt, my lord, the law does not expect a citizen to be calm in death-like situation. As the Honorable Supreme Court has consistently held that the law does not require a person to act as a coward or to flee when he face any imminent and lethal aggression. In the present case, Sumit Khanna was not confronted by an unarmed individual or a simple physical threat. He was faced with a JCB machine, a multi-ton mechanically powered earth mover machine being operated with clear and hostile intent. We submit that the threat was not merely speculative, but was active, lethal, and immediate. Your Lordship, I am going on my first submission, which is JCB as a lethal weapon and a reasonableness of fear. My Lord, our first substantive ground rests on the nature of weapon used against the accused. The law dictates that the reasonableness of an apprehension must be judged by the instrument of act. Your Lordship, I would like to draw your attention on a landmark judgment of Butta Singh versus State of Punjab, which is of 1991 and decided by division bench. In that case, the Supreme Court was seized of a matter where the aggressor attempted to run over the accused party using a tractor. The court held that a tractor, when driven aggressively towards a human being, ceases to be an agriculture tool and assumes that the character of a lethal weapon capable of causing instantaneous death. Your Lordship, if a tractor is a lethal weapon, then a JCB is an instrument of a mass destruction. It's heavier, more powerful, and equipped with a hydraulic arm that extends the kill zone beyond the chassis. The record confirms that the operator, Mr. Mahesh Kumar, was using this machine to break through physical barriers, the barbed wire, just moments before. And furthermore, Your Lordship, in Jayaprakash versus State of Haryana, the court reiterated that the heavy machinery used an instrument of aggression is equivalent to death weapon when such a machine is driven towards a pedestrian standing mere 5 feet away, as established in the record. The fear of being crushed is a natural biological reaction, Your Lordship. Sumit Khanna was physically dwarfed in standing in the front of the JCB. Any person of ordinary precedence would be gripped by a fear that the death was the only certain consequence if impact occurred. Your Lordship, moving to my next submission, which is dynamic of attack, aggressor versus defender. My Lord, the prosecution's own witness provide that most compelling evidence of our case. I draw your Lord's attention to the deposition of PW1, who is Naresh Kumar Gupta, who is arguably the most hostile witness of the defense, as he was the first complainant also who filed an FIR. PW1 admitted that the JCB was moving ahead and therefore the accused was moving back. This admission is fatal to the prosecution case. Sumit was not standing his ground in any act of resistance. He was moving backward, desperately trying to create distance between himself and the advanced machine. This is corroborated by the DW1 Kunal Bhatt also, who stated that the Mahesh Kumar moved the machine toward the Sumit, causing Sumit to fear for his life. When a machine that can crush concrete closes a gap of 5 feet, the apprehension of death is not retrospective invention. It's a factually present reality. The firing occurred only when the machine continued to close that gap, leaving the accused with no other option. And after all this, Sumit only targeted the leg of the JCB operator, but due to loss of balance, it was all happened due to an accident, Your Lordship. Your Lordship, moving to my next submission, which is immense of danger and the failure to escape. The prosecution may argue that the accused had a time to seek recourse to public authorities. We submit that the limitation applies only when danger is remote. As held in Yogendra Morarji versus State of Gujarat, the right of private defense is not extinguished if the police are not physically present to stop the specific blow. Even if calls was made earlier, the law does not require a man to dial the police, Your Lordship, while a multi-ton excavator is bearing down on him. Regarding the chance to escape, the Constitution bench in Jaidev versus State of Punjab held that moment of continuous danger, the law does not expect the defender to be calm or to look for an escape route. The terrain was uneven construction site with wire fencing. Turning one's back on moving vehicle is often more dangerous than facing it. And I would like to draw the attention of my lords on the very crucial fact that after the incident happened, Sumit was standing on the crime scene without moving an inch and without trying to escape. And he handed over himself directly to the police politely, without any aggression and without resisting, because he knew it was all done by an accident and also knew he will get justice by this court, Your Lordship. Your Lordship, moving to my next submission, which is the absence of golden scale and loss of balance. My Lord, I now address the issues of proportionality. The law is established in state of UP versus Ram Sarup, holds that a person facing a death threat cannot be expected to weigh his defense in golden scales. One cannot expect the precision of a surgeon from a man in a state of terror. Crucially, PW1 stated that accused number 1 lost his balance and then we heard the noise of firing. And DW1 also stated that if Mr. Sumit Khanna did not fire the gun at Mahesh Kumar, the JCB would have hit him and in probability killed him. This suggests that the fatal shot was not a cool-headed execution, but a chaotic discharge triggered by the accused, stumbling while retreating in fear. Under the doctrine of Darshan Singh versus State of Punjab, the court must view the circumstances through the eyes of accused, and a person who is stumbling and is scrambling back in is a person defending themselves and not punishing an aggressor. Your Lordship, in my final submission, I would like to state a recent judgment of 2025, Rakesh Datta Sharma versus State of Uttarakhand. In this, the facts of this case are like a medical practitioner. The deceased entered the doctor's clinic armed with a pistol and shot him in head. Despite being injured, the doctor managed to wrestle and the pistol away and shot the accused back, killing him. Your Lordship, the court clarified that the distinction between self-created danger and the reaction to aggression. Even if a person is armed, if the immediate cause of the violence is the aggression of the other party, the right of private defense is revived. Sumit may have had a gun, but he did not fire until the JCB was used as a weapon against him. The proximate cause of this fire was the movement of JCB, which forced the accused to react to a life-threatening situation. In the light of principles laid down in Puran Singh and in Rakesh Datta Sharma, it's clear that the Sumit Khanna acted to protect his life against a lethal mechanical threat. Your Lordship, in my conclusion, there are 4 points. First, the JCB was machine constitute a lethal weapon. Second, that the accused was in a state of retreat and reasonable apprehension. Third, the force used was a natural reaction to an imminent threat and cannot be measured with a mathematical precision. And fourth, even after the incident, Your Lordship, Sumit was standing there. Please consider, Your Lordship, it's not a behavior of a criminal-minded person. Your Lordship, I would like to proceed with the issue number 4, which states that whether the prosecution has failed to establish the existence of a criminal conspiracy between accused number 1 and accused number 2 under section 61 clause 2 of Bharatiya Nyaya Sanhita. Your Lordship, we most humbly submit that the conviction of accused number 2 Tanmay Khanna under section 61 clause 2 of Bharatiya Nyaya Sanhita is not just legally unsustainable, but it is a case of building a castle in the air. The absolute essential heart of a criminal conspiracy is a meeting of minds. Under section 61 clause 2 of the prosecution must prove that there was a concrete agreement between 2 and more people to do an illegal act. A conspiracy is not a feeling or a guess or a suspicion. It's a physical and mental agreement. And my lord, the record of this case shows a complete evidence vacuum. There is no direct evidence and the circumstantial evidence is broken at every link. The prosecution wants this to court to believe that because Tanmay is the brother of Sumit and the owner of the land, he must have planned the murder. But in the modern era of law, we do not convict people based on their family trees. I place heavy reliance on the judgment of ISAR Technology Limited versus CBI. In that case, the Honorable Supreme Court held that mere presence of suspicious circumstances is not enough to convict someone for conspiracy. The prosecution must positively prove that an agreement existed. In our case, the FIR, the charge sheet are silent on the most basic question: when was the plan made? When did the brother meet? And how did Tanmay instructed Sumit? Without answer to these questions, the charges are purely imaginary, Your Lordship. Furthermore, in CBI versus K. Narayan Rao, the apex court held that isolated acts coupled with suspicion do not constitute a conspiracy. Tanmay signing a development agreement is an isolated act, and Sumit going to the site is an isolated act. The prosecution has failed to stitch these together with the evidence of communication. The law requires a bridge of evidence, not a leap of faith, Your Lordship. Your Lordship, moving to my next submission, which is on CDR gap. My Lord, PW1 Naresh Kumar Gupta mentioned that Sumit made some phone calls and however, PW1 explicitly admits that the Sumit told everyone that police were coming. There is no testimony that he called Tanmay. There is no testimony that he received instruction from Tanmay. This gap is electronic evidence is a fatal blow to the prosecution theory. If the brothers were in conspiracy to stop the JCB driver through violence, would they not? They communicated. The absence of CDR linking Tanmay to Sumit on the day of incident, breaking the chain of conspiracy completely. It proves that whatever Sumit did, he did independently at the site. Your Lordship, moving to my next submission is the guilty of association. My Lord, the second ground I wish to argue is that the mere family relationship is not a proof of a crime. The prosecution has fallen into the trap of the guilty of association fallacy. Your Lordship, in the case of State of Kerala versus P. Sugathan, the Supreme Court warned against the tendency of the police to infer in conspiracy just because the accused people are related. The court held that families' ties are not a substitute for evidence of an agreement. Tanmay Khanna was arrested from his home. He was not at the site. He did not provide any weapon. He did not provide the car. His only crime, according to the prosecution, is that he was the Sumit's brother. This is vicarious liability being forced into a criminal trial where it does not belong. The prosecution must show that the Tanmay shared a common object and had knowledge of a specific illegal act. There is absolutely no evidence that Tanmay knew Sumit would carry a gun or that Sumit would react to a JCB machine by firing. The land dispute was a civil matter being handled through an agreement. This shooting was a separate, independent incident, and as already been discussed, that was done in a private defense. And in last, Your Lordship, I would like to proceed with the absence from the scene and lack of facilitation. My Lord, Tanmay's physical absence is a strong indicator of his innocence. He lives in Narayan Vihar, and the incident happened in Vasant Vihar. He was miles away, minding his own business at his home. Your Lordship, in the case of Yashwant versus State of Maharashtra, the Supreme Court held that to charge an absent conspirator, the prosecution must show that he facilitated the crime. How did Tanmay facilitate this? Did he provide the gun? No, it belongs to Sumit. Did he provide any kind of transport? No, there is nothing else. Did he provide any kind of signal? No, there is no evidence of call or anything. Tanmay did nothing on the day of the incident to help the shooting. Your Lordship, I would like to draw your attention in a case law of Keval Chand Memani versus S.K. Singh. The court ruled that no person can be charged simply because a complainant names them in an FIR, which happened in this case also, Your Lordship, without any kind of material evidence. The complainant, Mr. Gupta, named Tanmay because there was civil rivalry, but he could not point to a single criminal act performed by the Tanmay. The alleged is purely derivative and based on the grudges of a failed business deal. And also, Your Lordship, Tanmay was the only one who asked his sister Supriya to give them way to the construction site, as there was no other way to enter the site. If Tanmay had guilty intention, why would he do that? Your Lordship, please consider this fact. Your Lordship, moving to my next and final submission, which of lack of motive and logical inherence. Your Lordship, I would like to tell about the theory of motive. In case of CBI versus Ashok Kumar Agrawal, the Supreme Court held that framing charges requires a reasonable ground to believe. Does it make sense for a landowner like Tanmay to conspire kill a driver? If a driver is killed on his land, the project is halted by the police. If property becomes a crime scene, losing all its market value, he himself ended up in jail, unable to manage his assets. Tanmay Khanna, why would he take this kind of risk? The prosecution's theory is logically incoherent. It asks the court to believe that Tanmay planned a crime that effectively destroys his own business and freedom. This is not a reasonable ground for a conviction. In conclusion, Your Lordship, my Lord, the prosecution failed to produce a single call record, a single witness to an agreement, or a single act of facilitation by Tanmay Khanna. They have tried to convert a civil land dispute into a criminal conspiracy based on family surname. As law stands, suspicion, no matter how strong, cannot take place of a legal proof. Therefore, we most humbly submit that the conviction of accused number 2, Tanmay Khanna, under section 61 clause 2 BNS set aside, and that he acquitted to off charges and to interest of justice. This is our humble submission, Your Lordship. Your Lordship, if our lords any kind of question, please ask. Otherwise, the council seeks permission to proceed with the prayer.
Yes, Brother Balbir, would you like to ask any questions, sir?
No, from my side is fine. They can proceed for the prayer, subject to
right.
And Mr. Sanjay says.
Indeed, Your Lordship. The co-counsel seeks permission to proceed with the prayer.
Yes. Thank you.
Wherefore, in the light of facts, states issued, raised, arguments advanced, and authorities cited, submissions made hereto above, and those to be urged at the time of hearing, it's humbly prayed that this honorable court may be pleased set aside the conviction of accused number 1 under section 103 of Bharatiya Nyaya Sanhita, holding that prosecution has failed to establish the existence of intention or knowledge to cause death beyond the reasonable doubt. Hold and declare the alleged firing by accused number 1 falling within the general exception of accident or misfortune under section 18 of Bharatiya Nyaya Sanhita, the discharge having occurred in a sudden and unforeseen situation without mens rea. In the alternative, recognize the conduct of accused number 1 was protected by the right of private defense of body under Bharatiya Nyaya Sanhita in a view of imminent and advancing threat posed by the JCB machine, and caution set aside the conviction of Mr. Tanmay Khanna, accused number 2 under section 61 clause 2 of Bharatiya Nyaya Sanhita for want of proof of any prior meeting of minds of criminal conspiracy, and pass any order, direction, or relief that the honorable court may deem fit and appropriate in the interest of justice, equity, and good conscience. That's all, Your Lordship.
Thank you.
Now, if the honorable judges do not have further questions for the participants of team 574, with the permission, may I ask the team respondent 547 to start their oral submissions?
Yes, sir. Yes, please.
Team 547.
Thank you so much. Greetings to the honorable bench. This is speaker number 1 for team 547. My co-counsel will be speaker number 2. If your lordships permit, I may continue addressing this honorable bench as your lordship.
Yes, please continue.
Much obliged. Your lordships, as this honorable bench is well versed with the facts of this case, I would at the outset like to submit that the appeal is liable to be dismissed on the ground of limitation alone. The impugned judgment was passed on 11th of August 2025, and the appellants have approached this honorable court after an inordinate and unexplained delay beyond the statutorily prescribed period of limit. With that submission, the council will then move on to submissions under issues number 1 and 2. However, the council seeks permission from this honorable court to note that particular submission.
Okay.
Much obliged. Your lordships, we are appearing on the behalf of the respondent state, and with your lordship's permission, I shall address issues number 1 and 2 together, since both hinge upon the same legal inquiry, the mental element of the appellant and the availability, or rather in this case, the non-availability of statutory defenses. At the outset, my lords, I submit with utmost respect that this is not a case of ambiguity or misfortune. It is not a tragic coincidence. It is a case that flows clearly and inevitably from the circumstances. Your lordship, under section 103 of the Bharatiya Nyaya Sanhita, it embodies the law for culpable homicide that amounts to murder. It is settled that this provision does not require an intention to kill in every case. There is also the requirement of knowledge. The authoritative exposition of this case, like the learned counsel for the appellants relied on the case of Virsa Singh versus State of Punjab, the Supreme Court laid down 4 cumulative requirements: the existence of bodily injury, the nature of that injury, the intention to inflict that particular injury, and the sufficiency of that injury in the ordinary course of nature to cause death. This formulation has stood the test of time, my lords. It has also been consistently affirmed in the state of Andhra Pradesh versus Rayavarapu Punnaya, another case that the learned opposite counsel relied upon. The court clarified that once the accused intends to inflict a particular injury, and that injury is sufficient in the ordinary course of nature to cause death, the offense is murder, irrespective of whether the accused subjectively intended death itself. Your lordships, the inquiry is not into the internal psychology of the accused, but rather the objective nature of his act and the knowledge that is presupposed. When these settled principles are applied to this particular case, my lords, the result is unambiguous. On the date of the incident, appellant number 1 consciously arrived at the site carrying a loaded revolver, whether licensed or not. This was not a spontaneous possession. This was an active act by the appellant who brought the weapon into the scene of crime. He issued threats, my lords. He advanced towards the JCB, pointed the gun at the JCB driver, Mr. Mahesh Kumar, the deceased in this particular case. And this has been categorically admitted by the defense witness themselves before the learned trial court. He drew out the firearm, my lords, and discharged it from an approximate distance of mere 5 feet. The bullet struck the deceased on the forehead, a vital and vulnerable part of the human body. The post-mortem report establishes clearly that the cause of death was a fatal brain injury. The forensic report conclusively links the fact that the bullet was the appellant's revolver. Every limb of that said test has been satisfied, my lords. There is bodily injury and there is proof of its nature. There is intention to inflict that injury inferred from conduct, and the injury is unquestionably sufficient in the ordinary course of nature to cause death. At this stage, the appellant has also sought refuge in the plea of accident. With respect to this, the plea does not withstand legal scrutiny, my lords. Even assuming purely for the sake of argument that the trigger was pulled due to imbalance, the law does not isolate this final second of discharge. Criminal law examines the entire chain of conduct. The crucial question here is not merely how the said shot was fired. The question is why a loaded firearm with its safety lock off, a trigger is not an involuntary action, it is a voluntary muscular reaction, my lords, was aimed at the forehead of an unarmed worker at close range. Accident may attempt to explain a discharge. However, the deliberate aiming has not been explained by the counsel. In the case of Jayaprakash versus State, the Delhi administration, AIR 1991 SC 2082, it was held that the intention is to be gathered from the nature of the weapon, the manner of its use, and the part of body that has been targeted. A firearm directed towards a vital organ from close range admits only one inference, my lords, the intention to inflict that injury. Similarly, in the case of Raju versus State of Kerala, relying on Dibya versus State, the court held that causing injury to vital part of body with a deadly weapon necessarily imports intention. The law presumes that a person intends to cause the natural consequences of his voluntary acts. Even if this honorable court were to hypothetically assume the absence of intention, my lords, I submit that the requirement of knowledge stands independently satisfied. In criminal jurisprudence, it is the awareness that death is the most probable cause of one's act. When a revolver is discharged towards a human forehead from mere 5 feet, death is not speculative, my lords. It is not a remote consequence. It is a natural and most probable consequence and satisfies the all probability standard articulated. Your lord, this is not a case of a stray pellet that accidentally hit the deceased. This is not a ricochet. This is a case of direct firearm discharge into the most vulnerable region. Therefore, the conviction under Section 103 is firmly grounded in both law and evidence. My lords, moving on to the fact that the councils have claimed the protection under general exceptions. Having established that the act falls squarely within the ambit of Section 103, it must be emphasized that general exceptions are not mere interpretive tools. They are statutory shields available only when every condition prescribed under Chapter 4 is strictly satisfied. My lords, the council claimed for Section 18, that is accident. Section 18, my lords, grants immunity only when the act is done accidentally during the performance of a lawful act in a lawful manner without negligence and without criminal intention. Each of these conditions are cumulative. In the present case, the defense fails at every threshold. The act in question is not merely the pulling of the trigger. The act is the brandishing and aiming of a loaded firearm at another human being. That act is not lawful and has been categorically admitted again by DW1, my lords. This act is not protected and constitutes in itself criminal intimidation, which my co-counsel will be dealing with. Even assuming lawful possession of the firearm, my lords, the law draws a sharp distinction between its lawful possession and illegal use. A firearm is not a neutral object. Its handling requires heightened duty of care. Introducing a loaded weapon into a heated civil dispute, no matter how heated, by its very nature is negligent. In the case of Keshavlal versus State of Madhya Pradesh, 2002 3 SEC 254, the Supreme Court rejected the defense of accident, where the accused voluntarily created a dangerous situation involving a firearm. The court held that once a person places himself in a position of lethal risk, he cannot later invoke accident when harm ensues. In this particular case, the risk incidence falls upon the appellant number 1 who created that situation by brandishing the weapon and pointing it and issuing threats to all the workers in place. He explicitly told the JCB driver to stop work or else he would regret it. Similarly, in Atmendra versus State of Karnataka, the Honorable Supreme Court held that the plea of accidental firing was rejected when the accused claimed physical disturbance to the weapon. The court emphasized that careless handling of firearms negates the statutory requirement of absence of negligence to invoke Section 18, my lords. Further, my lords, the council has also claimed for private defense under section 38 of the BNS, which extends to voluntarily causing of death in certain situations. In this particular case, there was huge reliance placed on the fact that the JCB constitutes a lethal weapon. However, my lords, relying on the very same case that the learned counsel for appellants relied on, the Bhutto case, lethal weapon, that is when a truck transforms into a lethal weapon only when it aggressively moved forward towards the deceased. In this particular towards the accused. In this particular case, the absence of any evidence to prove the fact that the JCB was moved aggressively towards the appellant number 1. Further, my lords, the onus or the burden of proof under general defenses under chapter 4 of the BNS falls squarely on the appellants in this particular case per section 106 of the Bharatiya Sakshi Adhiniyam. The burden of establishing general exceptions lies squarely on the accused. The appellants have produced no evidence to establish the same, neither before the learned trial court nor before this honorable court. And therefore, statutory defenses cannot rest on the bare assertions made by the council, my lords. Further, I would also like to emphasize on the fact, my lords, that DW1 themselves admit the fact that the gun was pointed towards the deceased, so categorically admitting the fact that the aiming was deliberate. This previous conduct has not been explained by the learned counsel for the appellants, my lords. The subsequent conduct has been placed a lot of reliance on the fact that he remained in the scene of crime. However, my lords, the previous conduct of entering the scene of crime with a loaded weapon, removing the safety lock of that weapon, deliberately issuing threats to every worker in that particular place, and further pointing deliberately that particular weapon in this towards the direction of the deceased, all constitutes conclusively towards the fulfillment of section 103, therefore substantially excluding the exceptions under chapter 4 of BNS, particularly under sections 18 as well as 38. With that, the council submits that the conviction under section 103 BNS deserves to be upheld and the appeal deserves to be dismissed. With that, my lords, I submit as to issues number 1 and 2. And if my lords have no further questions, I would like to call upon my co-counsel to deal with the rest of the issues.
I have some questions.
Much obliged, my lords.
Now, you have seen the prosecution witness number 1.
Yes, my lords.
PW1. Now, knowing fully well that the dispute is going on the land, why did PW1 ordered his person to run the JCB, and he has himself admitted to break the barbed wire fencing? Now, whether in such situation, will it not constitute mitigating circumstances for a person to protect his land? And if need arises, to use reasonable force in his self-defense? It was admitted position is that the land belonged to he and his brother and sister. All three were adjoining land. So they had also a reason that if there is certain dispute in between, without that dispute is being thrashed out in the court, and admitted position is that the suit was going on, why did he order his person to run the JCB? What is your explanation on this?
Much obliged, my lords. My lords, in this particular case, there was a construction agreement that was entered into with appellant number 2, that is Thanmay Khanna. In this particular case, in furtherance of that agreement, there was leveling of land that was taken place, and it is also admitted that the sister of both the appellants gave way for the JCB to enter into this particular piece of land, therefore conclusively showing the fact that there was consent on the co-owners. Now, appellant number 1, if he has any issues, he may raise the same. There is no bar on that. However, brandishing a weapon and issuing threats for the lawful conduct of an activity in furtherance of a lawful contract is illegal, my lords, and also constitutes criminal intimidation, like my co-counsel will establish.
At the same time, you have seen that they are also virtually forcibly trying to do the leveling in the name of the agreement. So they are themselves also going on the crime scene when there is objection by one of the co-owner of the land. Then was it not appropriate for PW1, who happens to be the owner of the partnership firm having the agreement, to stop the work and first let them settle their dispute, then to start the work?
My lords,
What
it
is your
is
answer?
yes, my lords. It is humbly submitted that in this particular case, while PW1 may have had other recourses, this particular act in furtherance of the contract is lawful, and further, it does not warrant the extreme reaction of the appellant number one. The reaction being causing death of the JCB operator by deliberately aiming a lethal weapon, a firearm that was loaded in his direction and discharging it towards his forehead, causing his death. This is not warranted in any circumstance, my lords. Yes, he may have raised protest with regards to the leveling of land. He may have had other recourses by going ahead and settling this civil dispute within his family. However, PW1 was merely conducting his lawful activity per the contract, and any issues were to be settled peacefully. And the escalation here is not attributed to PW1, but rather to the appellant number one, both admitted by PW1 as well as DW1, my lords.
I'll just quickly add to it. You have seen the PW1 witness statement. There is no dispute that the accused called police, and he said the police is about to be on a spot. Then the PW1 says that we did not wait for the police and we continued our work. And he ordered that the breakaway of the barbed fence. So the immediate recourse which was available to him, and I'm testing the intention here. The immediate recourse was for him in a land dispute going on was to call the police immediately. And he, as a matter of fact, called the police, and police was awaited on the spot. What transpired thereafter is not going to dilute that the intention was not, and the intention to the nature of the allegations which are made and with the findings which have been given. These are not noted by the trial court. How do you address that? The order should not be sustained, such an important fact that the police was called to the spot at that point in time. Police, this was not waited to. And when there was a land dispute which is going on, is it right that you can proceed on that basis to say, and the complainant particularly, and the prosecution supporting that story?
Much obliged, Milas. To answer your question, firstly, the fact that phone calls were made to the police is not categorically admitted by PW1. He simply says that phone calls were made and that the appellant number one said that the police were coming to the spot.
No cross on that.
Of course, Milas. Going ahead with assuming the facts laid out in this particular case were that the police were called, it is also submitted that PW1 was simply doing his job. Here, the intention, even if we concede, knowledge is still there, my lords, under section 101 of BNS, which defines culpable homicide amounting to murder. Like I established in my submissions, there is pure knowledge as to the fact that the fatality of the injury would, in all probability, lead to death. In this particular case, the deliberate aiming of the weapon, along with the previous conduct of the appellant number one, wherein he brandished the weapon, issued threats to all workers, told the JCB to stop working or he would do something that he would regret, all of which must be seen cumulatively to form an unbreakable chain, wherein the appellant number one definitely had the knowledge that his conduct would lead in all probability to the death of the deceased, and thus qualifies as culpable homicide amounting to murder, and therefore liable for the conviction to be upheld, my lords.
Noted. Thank you.
Much obliged, my lords. It was a pleasure pleading before this court.
May it please this honorable bench. This is Speaker 2 for Team 547. The council seeks permission to continue to address the benches, my lords, or your honors, alternatively.
Right.
Much obliged. My lords, council shall be dealing with issue 3 and 4, which is with regard to the conviction of the appellants under section 61(2) of the BNS and sections 351 and the respective sections of the Arms Act against the appellant one. My lords, at the onset of it, the council submits that my learned friends have not contested the convictions under sections 351 and Section 7 and 27(3) of the Arms Act. So may it please be noted that the council shall still argue on the same for the upholding of the said sections. Assuming my lords are with me, I shall continue with the third issue. Much obliged. My lords, issue number 3 is with regards to the convictions of the second appellant and the first appellant under section 61(2) of the Bharatiya Nyaya Sanhita. Your Lordship, Section 61 of the Bharatiya Nyaya Sanhita criminalizes an agreement between two or more persons to commit an illegal act or a legal act by illegal means. The foundational principle governing conspiracy has been laid out by this Honorable Supreme Court in the case of Kehar Singh versus State, 1988 3 SCC 609, where it held that the most essential ingredient of conspiracy is the agreement itself, and that the offense is complete the moment such an agreement comes into existence. The position was further reiterated in the case of Nur Muhammad versus State of Maharashtra, 1970 1 SCC 696, wherein the Supreme Court categorically held that criminal conspiracy is ordinarily established through surrounding circumstances and previous and subsequent conduct. Lords, while it is true that mere relationship is not sufficient by itself, conspiracy can be informed where the relationship is coupled with a common motive, opportunity, and a coordinated conduct. Your Lordships, the position, just to reiterate, is that direct proof of conspiracy is not required. The agreement may be inferred from conduct, and circumstantial evidence is sufficient, and the court must look at the cumulative effect of all these facts. Applying the same principles in the present case, Your Lordships, the prosecution has successfully established a clear conspiracy between the two appellants. Lords, the second appellant in this case is not a distant or an antecedent party to the whole crime at scene. He owns the disputed land. He has executed 2 land development agreements with the prosecution witness 1 or the complainant. He stood to benefit directly from the obstruction of the construction, and he was also a close contact, a brother to the first appellant. My Lords, the second land development agreement that was issued on the 12th of September 2024 was executed barely a few weeks before the incident. My Lords, significantly on the very day, that is the 12th of September, appellant number 1 arrived at the site and issued explicit threats to the complainant, stating that he would burn everything down and ensure that the work was stopped. Plus, the timing is not coincidental. It clearly demonstrates a prior knowledge and coordination, because it is inconceivable that the first appellant would be aware of a freshly executed land development agreement unless the second appellant had informed him of the same, which establishes the fact that there was a communication and agreement between the two appellants. Further, Your Lordships, the evidence reveals that for nearly 2 years preceding to the said incident, appellant number 1 would persistently obstruct construction activity, issue threats, and create hurdles on sites that were all owned by the second appellant. Lords, again, it's a normal recourse that the second appellant could take is to probably approach the police or the court that the said obstruction was happening. However, the second appellant was silent throughout the same. This prolonged campaign finally, my Lords, culminated on the date of the incident, that is 6th of October, where the first appellant arrived armed with a .32 caliber revolver and finally fatally shot the deceased. Therefore, the sequence clearly reflects a common motive, which is the stopping of the constructions for a shared proprietary interest. My Lords, both the said appellants intended to gain something out of the said construction, given that there already existed property disputes within the family on the said land. There was a sustained coordinated conduct that is established by the act of the second appellant for not even communicating that the said obstruction caused certain losses, not just pecuniary, but losses to the second appellant. Lords, and also the eventful execution of the unlawful object, which was done through the murder of Mahesh Kumar, the deceased. When all of these facts are viewed cumulatively, they form an unbroken chain leading to the conclusion that both the appellants acted in pursuant to a pre-existing element or an agreement which therefore satisfies the test that was laid in Nur Muhammad, that the previous and the subsequent conduct of the appellants can lead to the establishment of an agreement. My Lords, it can be contended that why is just the first appellant being charged and sentenced under section 61(2), whilst the second appellant has not been convicted under the same. However, my Lords, the council would draw the attention of the Honorable Court to the case of State of Tamil Nadu versus Nalini, that is 1999, 5 SCC 253, wherein the Honorable Supreme Court clearly held that some conspirators may be charged with conspiracy while the others may be charged with only the substantive or the subsequent offenses of the same, and that the same does not invalidate the conviction of the other conspirators. Here, my Lords, the first appellant has already been convicted for murder and criminal intimidation. Therefore, his role as a co-conspirator stands judicially established. Therefore, my Lords, the conviction of the second appellant under section 61(2) of the Bharatiya Nyaya Sanhita is perfectly valid, and the learned trial court has made such conviction only after taking into consideration all facts and law into consideration. With that being put out, the council seeks permission to move on to the fourth issue, which is with regards to the conviction of the first appellant under section 351 of the BNS and the respective sections of the Arms Act.
Please go ahead.
Much obliged, my lords. My lords, section 351 creates a separate offense for criminal intimidation itself, which is complete the moment a threat is communicated with an intent to cause alarm. My lords, given that the aspect of intimidation is very in line with the way in which the arm was used, the council seeks permission to interrelate the matters and go forth the same.
Right, please.
Much obliged, my lords. And Section 7 of the Arms Act prohibits unlawful use of firearms or any ammunitions, and Section 27(3) is the punishment with regards to the same, even by a valid license holder. My lords, in the present case, the sequence of facts are that appellant number 1, post entering the crime scene with a loaded .32 caliber revolver, sought to intimidate the complainant itself at the very onset by pointing the revolver at the complainant, issuing explicit threat towards him in order to compel the stoppage of a lawful construction that was taking place. Thereafter, when the complainant did not concede to the same, he pointed the weapon at the JCB driver who was merely doing his part of work, and then thereafter fired the fatal shot that took place. My lords, as stated, Section 351 of the BNS talks about 3 major elements that need to be established for the charge of criminal intimidation, which is a threat of injury, a specific intention to cause such alarm, and an intention to compel the victim to do or to omit an act which they're legally entitled to do. My lords, in this case, it was not just on the date of crime, that is 6th of October, wherein the appellant number 1 has entered into the site and issued such threats, as put forth before this honorable court prior to that, 2 years continuously or consecutively, the appellant number 1 would just enter into the site and issue explicit threats and very using non-parliamentary languages for the stoppage of such construction. My lords, the whole aspect of brandishing a loaded firearm itself constitutes the fact of there was a specific intention to cause alarm and to cause a threat of injury. My lords, further, the aspect of Arms Act, given that the council is dealing with both of it together, is that the RFSL reports that can be found in the Moot Proposition 19 to 22 conclusively established that the bullet was recovered from the bullet that was recovered from the deceased was fired from appellant number 1's revolver. The same has not been contested by my learned appellant friends either. Noting that even though the appellant number 1 held a valid license, which however the first appellant has failed to produce during the course of the trial, using a firearm to commit murder and criminal intimidation constitutes use in contravention of Section 5 and Section 7 of the Arms Act, thereby attracting Section 27(3), my lords. The whole aspect of conviction under Section 351 is deemed to be established due to the fact that the whole sequence of events note that he held the revolver, he brandished the revolver at not just the deceased, however, the complainant and the other people that were there at the construction site too. The same has been categorically also established by not just the prosecution witness, but also the defense witnesses too. And the same has been mentioned in the charge sheet too. Therefore, my lords, the intimidation that the first appellant intended to do has been proved through the usage of firearm, not just to criminally intimidate, but to also, with the knowledge that such triggering of the trigger would cause a fatal shot, murder of the said deceased, and also forensic linkage that interrelates the same. My lords, the learned trial court has arrived at the said conviction relying upon consistent eyewitnesses' testimonies, RFSL reports, and the conduct of the accused before and after the incident. And as my co-counsel already dealt with it, mere presence of the accused on site post the said incident does not merely mitigate the whole aspect of whether or not he intended to cause the same. And my lords, as the court would appreciate that appellant courts do not necessarily, or in general practice, don't interfere with well-reasoned finding unless such manifest illegality is shown, which is very absent here, my lords. Not merely the manifestation, but even an iota of illegality has not been proved by the prosecution and the apologies, my lords, the appellants in this matter. thereby not warranting the intervention of the Honorable Appellant Court in the findings of the learned trial court. With that being said, the council seeks permission to move to the prayers on behalf of the state.
No, there are certain questions.
Yes, my lords.
Now, with respect to appellant number 1,
Yes, my lords.
so far as criminal intimidation is concerned, now in the given facts of the case, where admittedly the accused number 1 is the co-owner of the land. Now, on his land, PW1 is, of course, in the name of having entered into an agreement, but he is forcibly trying to level the land, and he has directed his driver of JCB to run it on the land, and even to the extent of he himself has admitted to break the barrier. Now, will it not constitute intimidation against the accused person? And accused can you not say that accused also was well within his right to protect his property, and he is having a licensed revolver, so he is entitled to carry it to protect his property. So in that case, will it not constitute mitigating circumstances against accused number 1? Please explain.
Much obliged, my lords. My lords, the whole aspect is that there is no license that's been placed by the accused during the course of the trial that deems that he was a valid license holder of the .32 caliber. With that set aside, my lords, understandably so that the accused is a co-owner of the said land. However, my lords, the whole ownership of the same is under dispute. And equivalent to that, appellant number 2 is also a co-owner to it, and the complainant merely acted in furtherance of the agreement that he entered with the second appellant. Therefore, there was knowledge that it was being done, and it was in no way to intimidate the accused at large. And the said barbed wire fencing that he aimed at destroying was given that it was put forth or put up illegally, which was always being tried to level, my lords.
One more question.
Yes, my lords.
Now, so far as appellant number 2 is concerned, what are the ingredients of conspiracy between accused number 1 and 2 on the basis of which the conviction can be sustained?
My lords, the whole aspect is that there must be a common intent to cause an agreement of such say to cause certain illegal act to be done or to not to be done. There is essentially a common motive which may be illegal in nature in furtherance of the same, my lords. That being the elements. Here the common motive is to stop the said construction. And the fact that irrespective of how prolonged there was obstruction by the first appellant on the land so allegedly owned by the second appellant continued to remain silent, thereby establishing the fact that there was some sort of understanding or agreement between the two brothers. And the intent or what was their takeoff from this was their shared proprietary interest over the land. Given that the sister, who also owned the adjacent property, also equally probably shared the rights over the said land, the two brothers aimed at getting a lot more out of the whole land. That was it, my lords. And to stop the construction was their aim.
Thank you. Balbir.
Yes, just to add what my friend said, is it not a self-contradicting argument for the prosecution to say, on one hand, there was a dispute between the brothers. On the other hand, you are saying the meeting of minds. Now, is that not a self-contradictory argument so far as the conspiracy is concerned? Because your whole premise is saying that you had an agreement with one brother. The second brother was not agreeing to. Although the principal accused had put in a board there, which was very visible, which is coming out of the complaint that the property is under dispute, all because the description is not given what was written on the board or what the description given. But I'm presuming this was a knowledge to you. You mean the developer. Now, therefore, it's not a self-defeating argument when it comes to say on one hand, meeting of mind, and second hand, that there was a dispute between the brothers which are not allowing to it. How do you address that on a conspiracy argument?
Yes, my lords. My lords, when I say the dispute on the land was a familial thing, given that it is well established through facts that there was also a sister that owned the adjacent property, The dispute over the land could have been shared between all the three siblings and not merely limited to the two brothers, thereby establishing that there could have been a conspiracy between, there is a conspiracy between the said two appellants.
Right. Okay. Thank you.
Lords, with your permission, the council seeks permission to move to the prayer.
Please go ahead.
Much obliged. Wherefore, in the light of the facts stated, the issues raised, the arguments advanced, and the authorities cited, it is most humbly and respectfully prayed before this honorable court to dismiss the present appeal as not maintainable on the merits of no condemnation and dismiss the appeal and uphold the judgment in the order dated 11th of August 2025, passed by the learned sessions judge, South District Circuits Court, affirm the conviction and the sentence awarded to accused number 1 under section 103, 151 of the Bharatiya Nyaya Sanhita and section 7 read with 27(3) of the Arms Act, and to the accused number 2 under section 61(2) of the Bharatiya Nyaya Sanhita, and or render any other order, direction, relief that it may deem fit in the best interest of justice, equity, and good conscience. For this act of kindness, the respondent shall forever duty bound free. It was an honor to plead before this honorable court.
May I please ask the honorable judges if they have further questions to be put to the participants?
No, I think they can go ahead with their rejoinder and sub-rejoinders.
Yeah.
So if team 574 want to start with their rejoinders.
Your Lordship, council seeks permission to start with the rebuttal points.
Please.
Your Lordship, first of all, the respondent's timeline is legally impossible, as we in the year of 2025, but they are responding in the case in 2026 in their memorial, as the respondent at their responding in the year of 2026, yet the trial court already gave its final judgment on August 11, 2025, and we immediately moved to the Honorable High Court also in the same year. Therefore, the prosecution cannot justify any new action or a response in 2026, as it violates the judicial hierarchy and the finality of the 2025 trial court judgment. And second, Your Lordship, the response reliance on the section 35 of Arms Act is legally flawed and factually misplaced. Section 35 specifically deals with the criminal responsibility of person in occupation of premises, and it is only triggered when arms are found in a place occupied by 2 or more persons under a suspicious circumstances. And in the present case, there was no joint possession, since the weapon was not recovered from a shared premises where multiple people could have said to have joint control. Section 35 cannot be evoked to create a fake narrative of a joint liability or conspiracy. Third, Your Lordship, our learned opponent that it was a targeted shot on the head. Why did the accused wait until he was losing his balance and being chased by a 10-ton machine to fire? Does the prosecution believe a person can take a perfect aim while falling backward in the fear for his life? And also the PW1 and DW1 stated the same thing. Our learned opposite counsel stated that the JCB was not moving towards the accused. Can the prosecution explain why their own main witness admitted in his record statement that he was the one who instructed his employee, and according to DW1, that due to the instructions, Sumit feared for his life? And also PW1 stated that the weapon was not drawn only after the machine moved. Are they now calling their own complainant a liar? And Lordship, moving to my next rebuttal point is that my learned opposite counsel stated that their arguments that the appellant did not deal with the section 351 of BNS and section 7 and 27 clause 3 of Arms Act, as there is not a single document, Your Lordship, says that Sumit threatened anyone with a gun. And also PW1 says that he took out the gun when he was in front of the JCB. There is no case of section 351, and hence that was a licensed gun. Section 7 and section 27 clause 3 automatically dismisses. And also Moot problem is silent on this issue, that court asked license or not. That's all, Your Lordship.
Thank you.
Thank you.
Team 547, if you have for rejoinders.
Yes, my lords, if we may be given 1 minute to just frame our arguments and get back to you.
Please.
Yes, yes.
With Your Honor's permission, the council seeks to proceed with the search orders.
Please go ahead.
Much obliged. My lords, my learned friend spoke about the targeted shot, that the shot was being fired due to imbalance, is a claim that is made by the appellants and the learned counsel for the appellants, and therefore, my lords, the onus of proof with regards to establishing the same is on them and not on the prosecution. My lords, with regards to the Arms Act, the fact is that the appellant claims that they held a valid license. However, again, the onus of proof to prove that Section 7 is not attracted towards them again falls upon the appellants themselves, and the prosecution merely met out its essential requirements, thereby establishing the charges under Section 7 and 27C of the Arms Act. That shall be it from the respondent's side. Thank you.
Therefore, with permission of the honorable judges, may we please conclude this moot court proceedings?
Yes, please.
Yes.
I request the honorable judges that our team will be coordinating with the honorable judges for the markings to the participants, and participants are requested to stay in the virtual meeting. I request my senior colleague Anu Singh ji to kindly take this forward.
Thank you, Aditji. The final oral rounds of the 4th National Virtual Criminal Moot Court Competition have now come to an end. And what we have witnessed today is not just a competition, but a display of learning, courage, and growth. Each team that stood before the bench today has taken a meaningful step forward in their journey of future advocates. Now we are especially honored by gracious presence of our respected academic leadership. It is my proud privilege to welcome Assistant Professor Deepsika ji. Your vision and leadership have played a pivotal role in promoting academic excellence and experimental legal learning such as moot court experiments. Over to you, Deepsika ji.
Good evening, everyone. Respected judges, esteemed faculty members, and my dear students. I'm Dr. Deepshika, Assistant Professor. As we reach the conclusion of this moot court competition, before the results are announced, it is important to pause and acknowledge what we have truly take place today. A moot court is not merely about winning or losing. It's about learning to think like a lawyer, argue with clarity, research with discipline, and advocate with integrity. Over the course of this competition, each team has demonstrated rigorous preparation, intellectual courage, and respect for the spirit of law. Standing here after the finals, every participant is already a winner. I always says that everyone who is participating in moot court is already a winner because they stood before the bench, defended their arguments under scrutiny, and uphold the dignity of advocacy. To those who argue today, remember that in the legal profession, success is not defined by applause or trophies alone, but by fairness, ethics, and perseverance. Every question faced, every rebuttal made, and every moment of silence before an answer. These experiences are shaping you into responsible officers of the court. As we await the result, I urge you to carry forward the lessons learned here, disciplined in preparation, humanity in victory, and grace in defeat. The courtroom of life will test you far more than this hall, and what you have practiced today will serve you well tomorrow. I congratulate all participants for their dedication and wish them continued success in their legal journey. Thank you, and all the best to both of the teams.
Thank you, Deepshika ji. Now I welcome Sri Baldev Raj Mahajan ji, Senior Advocate, former Advocate General of State of Haryana, to kindly address the gathering.
Baldev sir. Baldev sir. Next question. Next. You have to answer.
एक second. I welcome Baldev sir. Kindly address the gathering.
Issue है. Please enable the video.
Sir, your mic is mute. I'm requesting to unmute it.
Yes, he's there.
Please, sir.
नमस्कार सबको. Sorry, I have joined it just now.
Sir, we can't hear you.
I was not earlier aware, and I wish all the best to all the participants. It is
Sir,
a
you are
good
not
event.
audible.
Oh, sorry.
Please unmute yourself, sir.
We can hear him. Now he's unmuted.
Yeah, sir, please unmute yourself. Please, sir.
Namaskar. Since I have joined just now, I was held up somewhere. I wish all the best to all the participants and also to the organizers. I will just now have joined it, and I will say I will not be, because I could not join it in time. Thank you very much. No time.
Sir. Thank you, sir. I welcome Sri Padmakanji Advocate and requesting sir kindly address the gathering. Padmakant sir. Ladies and gentlemen, after witnessing the thoughtful arguments and having deliberated upon the issues, the honorable judges have graciously agreed to share a few words of guidance and encouragement of our participants. Their observations are invaluable as they come not only from the bench but also from years of experience in the practice and interpretation of law. Now I am honored to invite Senior Advocate and former ASG Supreme Court of India, Sri Balbir Singh Ji, to kindly address the gathering.
Thank you so much, Anu Singh Ji. I believe your name is right on the screen.
Please, yeah.
And I'm absolutely honored for inviting me to judge this kind of a moot competition. And Podar Saab, thank you so much for involving me in this exercise. And I'm absolutely impressed with the level of preparation both the teams had, which had gone into it. So first of all, I congratulate all the participants, and I'm sure a lot of hard work has gone and their teams would have done a good job for them. Legal profession, as all the luminaries sitting here, they will confirm, and the honorable judge is also here, that this is a consistent exercise of hard work over a period of time. What you develop in your earlier year, not only in law, in general aspect of life, outside law, plays an extremely important role in a later part of your life. Generally, they say that the lawyer's life, when it comes to being independent and being on their own, takes usually to 7 to 10 years. And the first 10 years possibly are not the right way to judge it, but to continue to work hard and see that you go in the right path. So therefore, the initial years are, I would say, the more of an investment which are to be done. Second aspect, which for the young lawyers from my side, is that opt for the areas where you think you can sustain your interest in the initial years. And those areas can sustain you as well for initial period of time, because it takes a bit of time when you start identifying yourself, which area of work you want to be in, which courts you want to be in, depending on where you live, what kind of work you do. So that choice of initially starting your life, if you have that option, is extremely important to sustain outside. Coming specifically to Moot, all of you were very well prepared. I think you had done your job as a student, what you possibly could have done. And you were absolutely on the top of your job. Just as since we have spent more years in the profession, can advise you on a few things which you should take note of. Like this particular Moot, you were in the first appeal, and therefore you had a trial court order. Most of the arguments made by both the sides, and it's not a pointing out any specific shortcoming, but I'm giving you with my experience as a lawyer that you are hitting the order because there was an order which was passed. So therefore, both the side could have started with the whatever part of support they wanted to draw or the loopholes they wanted to point out in the order. So whenever you're in the first appeal, must attack the order or take a support from the order. That's the usual course. Since it was a first appeal, it could have been all evidences could have been argued. You could have moved other application to bring on other witnesses or the evidences which were required because this was a murder. And and ultimately this matter is going to go to the highest level. So therefore, starting point could have been that. Second is that you quoted so many judgments while making these arguments. But what importance factual aspect like a site map, when you look closely at a site map, you could have hit it from there to start saying that where the fence is, whether the fence was on the disputed plot or undisputed plot, where the JCB started from, moving from which part to other part. If you see your site map, there was sister's plot because the access was from the sister's plot. So there was nothing wrong in this part. Second part, again on a factual, when you closely look the pleadings, and that's the most important part in criminal matters, because everything stems from what has been pleaded, right from the stage of a complaint, FIR, and so on and so forth. When you closely look at, there are nuanced approaches which are there. Like, let's say the accused putting up a board. You could have always taken these kind of instances to say that although there was a board, but nothing mentioned on the board specifically, therefore assumption could have been drawn. Because in the first order, there was nothing specific which was given. So what I'm trying to emphasize is, and especially in a criminal matters, more than law, look at the fact and look at the evidences which are there in front of you and try and focus those on that. Since you're in a moot, I'm sure because the way you are to be numbered, therefore knowledge of law, case laws and all to be given. But looking at it from a lawyer's perspective, and especially in a criminal matter, facts are very important. Second aspect is when you fit a law, rather than rattling a case law saying that in this and so and so happened. And this is just an advice. Pick up a fact where you think that you need a support, try and address along with the fact that this is a particular case law and this event happened. Making 5 or 10 case law is not very relevant, but bringing in the most effective case law, link with the particular proposition you're drawing out the fact, I think the second aspect which I would point out. But these are broad journal guidelines that how you look at law, look at a particular briefing, and therefore you fit in to support that. That's what my advice to all of you. But I would say that all the best to young lawyers, and may life give you all the success. Keep working hard. And thank you once again for involving me in this Moot competition.
Thank you, sir, for your inspiring guidance and encouraging words. They will certainly leave a lasting impression on our participants and motivate them in future legal journey. Next, I am honored to invite Senior Advocate and ASG Supreme Court of India, Shri S.D. Sanjay ji, to kindly address the gathering.
Very good afternoon to all of you. And I really feel privileged to be part of this young group, I say. Of course, there are some like us also. And I'm thankful to Sanjay ji for involving me in this, because when we interact with youth, we feel something youth in us. We have also passed this phase in our life. And I say for a lawyer that you have chosen a very difficult profession. Don't think like in few days or few months or few years you can get success. You have to wait. You have to have patience, perseverance in you to become a successful lawyer in life. And let me tell you, one thing I noticed from your memorial today, that you people feel that giving a lot of case laws may help us in proving our points. No, it's not correct. I'll give you two things. That a lot of drafting in appeal, particularly in criminal appeal, does not help. I am reminded when I joined the legal profession in 1984, after passing from Campus Law Center, I went back to Patna for practicing. In 2 years of my practice, I got a murder case. It was a dowry death case. In the dowry death case, the presumption is against if the death is caused within 7 years period. It was a very difficult case. Then I had some occasion to deal with at the stage of trial, and then all were convicted. The appeal came. Now, I drafted a petition and went to a very senior criminal lawyer who was dealing with most of the appeals. He saw the draft. It was 25-page draft. He took the draft and said, so far criminal appeal is concerned, the appellate court looks into the original record and the witnesses' evidences and exhibits. It does not see much to the order. So you have to draft that. You have to mention that the judgment of the trial court suffers from error of law as well as error of facts. Even if you do that, that will suffice. But of course, my advice to you is that when you get an opportunity to draft a criminal case, you have to mention only relevant facts to attack the order of the trial court. So, and while doing it, you have to focus on your own points. You need not cite large number of cases because they will go unnoticed. You have few cases with you, hit on that by making your point, and where do you want to drive the court? Where do you want to take the court? And you all are young and you will be joining profession. Some of you may go for practice litigation in criminal side or civil side. One more advice I will give. When you are pursuing your studies, you may have liking for some subject. Now, during our days, we hardly had the choice, but nowadays you have the choice. Accordingly, you should have that subject for your legal profession, which is part of your passion, in which field you have interest. Like if somebody have got interest in criminal side, he should choose his profession and he should join a senior after passing out who is specialized in the criminal side practice. Similarly, if you have interest in commercial side, then you should join an office. During our period when we had joined profession, we have to mix with all and we have to deal with all. But now you have the choice. So if you are having passion for a particular subject, then you will excel in that field. And let me tell you, so for today, I am really confused. Who has done better? Because all four of you were excellent, and it is all had fully prepared your subject. Of course, so far as defense is concerned, they had a very hard case so far facts is concerned. And so far prosecution is concerned, they had some easy case for them to deal with. But both of you have done your homework excellently, and really we will be finding very difficult to judge. And don't worry about the result, that who is adjudged the best, because all of you are best. Let me tell you, all four of you are very best, and your preparation was all good. All of them, you have the skill in among you. You had argued your case very nicely. The flow of argument was wonderful, and of course, I had put certain questions from you because there was a marking on that basis also. How do you deal with the problem? How do you not only deal with the problem, but also the questions? So therefore, I had asked certain questions from you people. But let me tell you, you are all very good. And I wish all the best to all of you. You will do good in your future. Thank you.
Thank you, sir, for your genius words. I now invite Advocate Sri Darshanan Gaurji. Sir is the founder member of Akhil Bharatiya Adhivakta Parishad. Sir is former president of Ghaziabad Bar Association. Sir today completed 47 years in the field of litigation and enters 48 years with full enthusiasm. Also a guiding light for upcoming generation of lawyers. To kindly address the gathering. I welcome sir to kindly address the gathering.
पूज्य देवियों, अधिवक्ता परिषद दिल्ली प्रदेश के अध्यक्ष आदरणीय संजय पोद्दार जी, विक्रांत जी और इस मूट कोर्ट में भाग लेने वाले सभी प्रतिभागियों, वस्तुतः जिस सृजनात्मक एवं सकारात्मक परिवेश में अधिवक्ता परिषद दिल्ली प्रदेश के द्वारा देश भर के विश्वविद्यालयों के लिए यह मूट कोर्ट आयोजित की गई है, आप सभी को यह बताना उचित होगा, यह चौथी मूट कोर्ट का आयोजन है। एक और चीज आप सभी के समक्ष रखना चाहूंगा कि पिछले लगभग 2 वर्षों में मूट कोर्ट की तरफ जिस सजगता के साथ और जिस गरिमा के साथ दिल्ली प्रदेश अधिवक्ता परिषद ने कार्य किया है और कार्य कर रही है, उसके लिए निश्चित रूप से आप सभी प्रतिभागियों के लिए यह एक सौभाग्य का अवसर होगा। सभी प्रतिभागियों के समक्ष एक बात और मैं रखना चाहूंगा, जिस गरिमापूर्ण परिवेश में, जिस गरिमापूर्ण व्यवसाय में आप लोग अब प्रवेश करने जा रहे हैं, वस्तुतः वह बेहद निर्भीकता एवं त्याग की प्रतिमूर्ति के व्यवहार का प्रतिफल होता है। एक बहुत ही पवित्र व्यवसाय है। ये सभी आप लोगों ने इस मूट कोर्ट के आयोजन में और इसमें तमाम जो हमारे वरिष्ठ अधिवक्तागण के यहाँ आप लोगों को बताया गया, माननीय न्यायमूर्ति भी इसमें उपस्थित हुए, उन सभी का निर्देशन आपको प्राप्त हुआ। यह आप सबके लिए भी, हम सब कार्यकर्ताओं के लिए भी सौभाग्य की बात है। आप सभी के सुखद एवं समृद्धिपूर्ण भविष्य की कामना के साथ साथ एक बात और मैं कहना चाहूंगा, पुनः एक बार मैं धन्यवाद देना चाहूंगा आदरणीय संजय पोद्दार जी, जिनकी लगन के फलस्वरूप ये चौथा मूट कोर्ट दिल्ली प्रदेश अधिवक्ता परिषद के कार्यकाल में संपन्न हो रहा है, और इसके महामंत्री श्री विक्रांत गोयल जी को भी आभार कि उन्होंने यहाँ आप सभी के समक्ष उपस्थित होने का अवसर प्रदान किया। पुनः एक बार आप सभी के अच्छे, सुखद, गरिमापूर्ण भविष्य की कामनाओं के साथ धन्यवाद।
Thank you, sir, for encouraging us so deeply. It is our honor to invite Senior Advocate Sri Sanjay Poddarji, President of Adhivakta Parishad Delhi Pran, to kindly come forward to announce the result of the 4th National Moot Court Competition.
Namaskar. Result is awaited and we have to wait for the result. थोड़ा बीपी बच्चों का भी बढ़ेगा इससे। तब तक मैं कुछ अपनी बात रखना चाहूँगा जो मैंने अपने एक्सपीरियंस से गेन किया है। अभी डॉक्टर बलवीर सिंह मेरे अच्छे मित्र हैं, उन्होंने भी बात कही, मिस्टर एसटी संजय ने भी कही कि हम लोगों को वकालत में कोई शॉर्टकट नहीं है, 10 साल भी लग सकते हैं, डिफिकल्ट प्रोफेशन है। एक बात मुझे याद आती है जो मैं कहना चाहूँगा, जिसको हमने जिया भी है। सने पंथा सने कंथा, सने पर्वत लंघनम, सने विद्या, सने वित्तम, पंचेतानि सने सने। इसका मतलब होता है, सने पंथा का मतलब है जब आप जर्नी करते हैं, कोई भी अंडरटेक करते हैं, तो धीरे धीरे वो एक जर्नी भी कंप्लीट हो जाती है। जब कपड़े को बुना जाता है, धीरे धीरे कपड़ा भी बुना जाता है और वो एक अच्छा वस्त्र बन जाता है। पर्वत को लांघने के लिए भी छोटे छोटे स्टेप्स लेके हम लोग धीरे धीरे पर्वत के ऊपर भी चढ़ सकते हैं। विद्या जो है वो भी धीरे धीरे मिलती है। सनय वित्तम, पैसा भी धीरे धीरे आता है। ये 5 चीजें जो हैं हमें बहुत स्लोली मिलते हैं, लेकिन मिलेंगे। सो हमको टारगेट फिक्स करना चाहिए। आई ज्वाइन द बार इन 1989। फाइनेंस डिपार्टमेंट में या फाइनेंस के जो होते हैं इकोनॉमिक्स में, बैलेंस शीट सालाना बनती है, ईयरली बैलेंस शीट होती है। हमें बताया गया था कि आपको डेली की बैलेंस शीट बनानी है अपनी, कि आज क्या सीखा, आज क्या खोया। क्या आज का दिन बिना सीखे निकल गया तो माइनस, लाइबिलिटी आ गई, क्योंकि उस दिन तो खाना खाया है, खर्चा किया है, लेकिन एसेट साइड में कुछ आया नहीं। तो आफ्टर 37 years of practice, I am still working on daily balance sheet. This is what ultimately pays in the long run. No advocate can earn everything in the first year. It takes time. There is no shortcut. इसमें क्या चाहिए आपको? अभी कॉलेज में क्या होता है कि वी लर्न लॉ, बट आफ्टर डिग्री यू नीड टू नो द प्रैक्टिस। जो लॉयर का काम है, लॉ को जो सीखा है वो प्रैक्टिस में अडॉप्ट करना है। द डिफरेंस बिटवीन technical subject and legal subject is like this. Technical subjects are taught lawfully. Legal subjects are taught technically. So we need to know this. You are at the initial stage of your career. Focus. मेरे जो साथ काम करते हैं वो पूछते हैं डॉक्टर बलवीर सिंह कि आप याद कैसे करते हो? तो मैंने उनसे पूछा कि आप साइकिल चलाना कब सीखे थे, और साइकिल चलाना छोड़ने के बाद अभी भी आपको साइकिल चलानी आती है ना? क्योंकि साइकिल चलाना आपने रट्टा मार के नहीं सीखा, साइकिल चलाना आपने प्रैक्टिस से सीखा। जो आपने प्रैक्टिस कर ली वो कभी नहीं भूलोगे। विद द एप्लीकेशन ऑफ एडवांस टेक्नोलॉजी हमने राइटिंग लिखना बंद कर दिया है। दिस इज द बिगेस्ट प्रॉब्लम विच वी आर फेसिंग। जब आप लिखते हैं तो आपकी मसल मेमोरी स्ट्रेंथन होती है, लेकिन आप मेमोराइज करते हैं। लेकिन जब आप कंप्यूटर पर पढ़ते हैं या कुछ करते हैं, लिखते हैं, तो आपकी जो मसल मेमोरी है वो वीक होती जाती है। पहले हम लोग 100 नंबर टेलीफोन के याद रखते थे, अब मोबाइल में सारे नंबर फीड है, हमको अपना नंबर भी कई बार याद नहीं होता है, क्योंकि मसल मेमोरी फेल हो चुकी है। पहले हम लोग जजमेंट्स को हमारे समय पर हम बुक से पढ़ते थे, अब हम लोग सर्च करते हैं। सर्च करने में क्या होता है, सर्च इंजन में इफ यू डोंट पुट द करेक्ट वर्ड्स, कैच वर्ड, you will not get it. How? You must try to read the manuals. we have got AIR manual. Read it from that. Then look for the up-to-date knowledge, judgments. Read the legal portals daily. This will enhance your knowledge and practice. Right? Now, the difficult time for me. I have been watching since 24th January. 58 teams well versed with their topic. They participated in the competition. All were equally good. But the judges have to give marks. Marks are only an indicators. They are not assessment of your caliber, talent. 58 टीम्स में से अभी हमारे पास 2 टीम पहुंची हैं सेमीफाइनल, क्वार्टर फाइनल में. It was so difficult to select one team or 2 teams. We had huge discussion कि किसको रखें किसको ना रखें. 3 टीम में टाई हो चुका है एक सब्जेक्ट पर. इतनी अच्छी टीम्स हैं. दशानंद जी, जब हम लोगों को टीम के बारे में लगता था कि ये टीम नहीं आ पा रही, हमें बड़ा दुख लगता था. लेकिन फॉर्मेट तो है, एक को लाने के लिए हम दूसरे के साथ अन्याय तो नहीं कर सकते. हमारे इस प्रोग्राम को क्यूरेट करने में, उसको इम्प्लीमेंट करने में द टीम वाज लेड बाय मिस्टर अर्चित वासुदेव. ही इज वाइस प्रेसिडेंट लिटिगेशन, असिस्टेड बाय रिधिमा गौड़ जी, सी सेक्रेटरी लिटिगेशन. 2 महीने से वो इस पर काम कर रही हैं. उनके टीम के साथ 200 lawyers are working round the clock. It was very difficult. एंड हमें सबसे ज्यादा खुशी इस बात की है दशानंद जी, 170 टीम ने अपना इंटरेस्ट दिखाया था. रजिस्ट्रेशन 94 टीम्स ने किया. सिलेक्ट हुई इनिशियल स्क्रीनिंग के बाद 58 टीम्स. उसमें से सिलेक्ट होते होते 2 टीम हमारे सामने है अभी. देखिए कितना मुश्किल काम था. एंड आई मस्ट place my appreciation to my entire team. Names I must mention, otherwise उनकी मेहनत अधूरी रह जाएगी, मुझे ऐसा लगता है. कुछ समय लगेगा. अनु जी हमारी वाइस प्रेसिडेंट हैं आउटरीच. रीना सिंह जी हैं सेक्रेटरी ऑर्गेनाइजेशन. कुणाल रावत, मृदुल जैन, पुरु मुदगिल, ऋषभ मल्होत्रा, अभिषेक वशिष्ठ, रितु भारद्वाज, इन्होंने भी कंधे से कंधे मिला के काम किया. दीपा मलिक, सुशीला नारंग जी जो सब कार्यक्रम की सूत्रधार होती हैं. रितु शर्मा कौशिक हमारी थिंक टैंक की ब्रेन है. देन श्याम गुप्ता, संयम गुप्ता, मयंक, किम, विक्रांत गोयल जी हमारे जनरल सेक्रेटरी, प्रदीप आर्या हाईकोर्ट यूनिट के प्रेसिडेंट, सुमित जी, दीपक जैन, भावना शर्मा, विवेक भाई पटेल, डीके पांचाल जी वाइस प्रेसिडेंट हमारे दिल्ली यूनिट के, आदित्य देसवाल, आयुष सक्सेना, जीवेश तिवारी, जिनके जो हमारे जो सबसे बड़े एडवाइजर हैं हमारे, आकाश वाजपेयी, चित्रा गोस्वामी जी, राधा सिंह धोनी, निखिल, आशीष शर्मा, रुपिंदर जी, उन्होंने भी काफ़ी मेहनत की है. गीतांजलि त्यागी, ये हमारी एक बहुत अच्छी राइटर है। गौरव भारद्वाज, उन्होंने मूट कोर्ट को जज भी किया है। समीक्षा मित्तल, सुरभि सक्सेना एंड मृदुल जैन, रुपिंदर पाल सिंह जी, उन्होंने भी काफी मेहनत की है। अब मैं कुछ रिजल्ट मेरे पास आ गए हैं, तो मैं बेस्ट स्पीकर का बताओ पहले। जुड़े हुए हैं क्या ये? बेस्ट स्पीकर अभिनव फ्रॉम टीम 620 ISDS यूनिवर्सिटी ऑफ इलाहाबाद हैं, उनको स्क्रीन पर लाइए।
यस सर।
वेल डन। इस बच्चे ने
थैंक यू सर।
काफी मेहनत की है, डिस्पाइट हिज पर्सनल प्रॉब्लम्स। इनके घर में मेडिकल इमरजेंसी थी, फिर भी इसने रेलवे स्टेशन से, SD संजय सर, रेलवे स्टेशन से इस बच्चे ने पार्टिसिपेट किया। वेल डन। बेस्ट मेमोरियल, मैंने तो बोल दिया। 3 टीम असल में टाई हो गया है, और अभी भी अनाउंसमेंट से पहले फिर हमारी डिस्कशन हुई है, आप लोगों ने सुना भी होगा। लेकिन मेरा मन नहीं करता है कि मैं सिर्फ एक टीम को चुनूं बाय लॉटरी। इट विल बी अनफेयर, so we have decided as a special case to select all the 3 teams for best memorial. Team 520 है, 520 स्क्रीन पर लाइए इनको। 526 एंड 626। वेल डन बेटे, आप सबने अच्छा काम किया, अच्छी परफॉर्मेंस दी। Because of your performance, all the 3 teams are being selected for best memorial. The difficult time now. Result here आ गया ना, यही है। रनर अप टीम, कोई ये ना समझना कि रनर अप टीम का किसी का नाम लिया तो वो कमजोर है या कुछ कमी है। दोनों बेटर है, सब बेस्ट परफॉर्मेंस दिया सबने, बट वी हैव टू सिलेक्ट वन। टीम नंबर 7 574 is the runner up, Dr. Ambedkar, BR Ambedkar National Law University सोनीपत। बलवीर सर, ये नई कॉलेज है और ये फाइनल राउंड में पहुंची है।
Absolutely brilliant, Ajay.
Credit goes to their efforts. Hats
Absolutely.
off to them and their teachers.
Correct.
They are runner up.
Which college is this?
Slightly winner
Sanjay ji?
का नाम तो आ चुका है। टीम नंबर 547 PES यूनिवर्सिटी बेंगलोर। Just raise your hands, Bangalore team. 574. I have one advice for you. You need to tone down your aggression. It's a contest, not a fight. मैंने आपका कल भी क्वार्टर फाइनल भी देखा था। इतने एग्रेशन की क्या जरूरत है? आप किसी दिन डॉक्टर बलवीर सिंह को आर्ग्यू करते हुए देखना। फर्मली, फोर्सफुली, बट पोलाइटली। I am trying to learn this art from him.
Nani, I think Padar Sahab, you are.
And ultimately, the depth of your argument will be noticed and considered, not the voice of your sound of your argument. The argument should be sound, right? I am not criticizing you, Don't take it like that. You are the best team. Some corrections we also do every day. In judicial system is the only system where learned word is prefixed, learned advocate. Because every day we learn. Nobody writes earned advocate. Earning is immaterial. So, thank you. Congratulations to all the team. My gratitude and appreciation for Dr. Balveer Singh, Sri S.D. Sanjay ji, and Justice Anil, who has to go because of some commitment. We will share our appreciation and we are thankful to all the judges, the mentors who are present here. We are all here to guide the new bar and to shape new bar, new generation, new young advocates in the bar. I must say one more thing, that Adhivakta Parishad, in order to give encouragement and to facilitate young bar, we have started internship program. It was started from July last year. In the last year, we have given internship to about 400 to 500 students. This time we are giving internship to 450 students across the city. Then moot court competition. And we organize study circles for young advocates and other advocates. So this type of work Adhivakta Parishad is undertaking. Thank you very much and congratulations to all. One last announcement which I am required to make is certificates to all the participants and trophies would be sent to them by courier. Thank you very much.
Thank you, Badar Sahab. Thank you very much.
Thank you. Thank you.
Thank you so much, sir. Our heartiest congratulations to the winning team for their outstanding performance and well-structured arguments. Your hard work, clarity of thoughts, and courtroom discipline have truly set you apart. At the same time, I would like to commend all the participants who reached this stage and those who competed throughout the competition. Moot court is not only about the final result, it is about the learning, the confidence gain, and the courage to stand before the bench. Each of you who have argued leave the courtroom richer in experience and stronger in advocacy. We encourage you to carry forward this learning into your future academic and professional journey. Now, it is now our privilege to welcome Shri Sri Hari Borekar ji, Organizing Secretary, North Zone Akhil Bharatiya Adhivakta Parishad. Sorry, sir. Now, may I now invite Professor and Vice President of Akhil Bharatiya Adhivakta Parishad, Dr. Seema Singh ji, kindly address the gathering.
Namaskar to all of you, and first of all, my congratulations to the winning team and all the teams who participated and reached up to the level of quarter-final or semi-final. So unfortunately, I could not attend the entire, this moot court program, and I missed especially today's finals. But whatever I have heard from Sanjay ji, from Sanjay Poddar ji and rest, definitely I am very sure that it was a very learning experience for all the participants. And you learned a lot that how to address the court and how to understand law, how to understand the process of research and all. But there are few other things which are very much important, and I just wanted to mention because certain very important points were mentioned which are very important for all of you by Sanjay Poddar ji, and these points are going to be very helpful in the future once you are appearing before the court. तो संजय जी ने बड़ी अच्छी बात बताई जो उन्होंने एक श्लोक बोला, और बीइंग अ प्रोफेसर ऑफ लॉ आई वुड सजेस्ट यू कि कुछ चीजें आप कभी भी मिस मत करिएगा, बिकॉज नाउ यू आर गोइंग टू इन few years we will join the, or maybe in the coming 6 months you will join the bar. तो एक तो मुझे ऐसा लगता है कि सबसे ज्यादा आप लोगों को इस बात पे फोकस करना चाहिए कि पेशेंस, that is very very important, along with dedication, hard work and continuity, that is also very very important. You should never feel disheartened. तो आपको लगातार इस प्रोफेशन में लगे रहना, बिकॉज इट इज अ डिमांडिंग प्रोफेशन. एवरी डे यू आर गोइंग टू फेस अ न्यू काइंड ऑफ चैलेंज, सो एवरी डे यू शुड ट्राई टू लर्न समथिंग न्यू. और अभी जो संजय जी ने एक बड़ी अच्छी बात बोली कि आपका जो अब कंपटीशन है ना, वो कहीं ना कहीं आपको एआई के चैलेंजेस को भी फेस करना पड़ेगा. सो ऑलवेज रिमेंबर, ह्यूमन इंटेलिजेंस कैन नेवर रिप्लेस artificial intelligence can never replace human intelligence, but it is possible only in that circumstances when you are using artificial intelligence as a tool. तो इसे एक टूल की तरह इस्तेमाल करिए, डोंट बी सो मच डिपेंडेंट अपॉन इट. रीड करने की, राइट करने की प्रैक्टिस को आप कभी मत छोड़िए. ऑलवेज ट्राई टू लर्न समथिंग न्यू ईच एंड every day. Then only you will be you will be able to establish yourself in this profession, which is a very demanding profession, in next 2 3 4 or 5 years. तो बस मुझे इतना ही कहना था, और मैं विनिंग टीम को तो बहुत सारी बधाई देती हूँ. 2 out of 58, great, commendable, many congratulations to all of you. And संजय जी, विक्रांत गोयल जी, अनु जी, और जितनी भी पूरी आपकी अधिवक्ता परिषद की टीम है जो लगातार लगे रहे, और इन्होंने, आप लोगों ने इस बड़े प्रोग्राम को इतना सक्सेसफुल बनाया. और मेरी स्पेशल कॉन्ग्रेचुलेशन इसलिए भी क्योंकि आपने देश के हर हिस्से के लोगों को इस कंपटीशन में पार्टिसिपेट करने का एक मौका दिया, जो यूजुअली बहुत सारे जगहों पे पॉसिबल नहीं हो पाता. और मैं देख रही थी जैसे वो इलाहाबाद का जो बच्चा है, मेरी उसको कॉन्ग्रेचुलेशन है, क्योंकि उसका कॉन्फिडेंस आप देखिए, उसकी आप लगन देखिए कि उस सर्कमस्टेंसेज में भी ही पार्टिसिपेटेड इन दिस मूट कोर्ट प्रोग्राम. तो आप सबको मेरी बहुत सारी शुभकामनाएं. और संजय जी, आने वाले समय में आप और आपकी पूरी टीम इसी तरीके से ये मूट कोर्ट कंपटीशन आयोजित करते रहिए, और ये हर बार पिछली बार के कंपैरिजन में और ज्यादा सक्सेसफुल हो. तो सारे बच्चों को मेरी बहुत सारी शुभकामनाएं और बहुत सारी बधाई आप सबको, और दिल्ली प्रांत की पूरी टीम को भी बहुत बहुत धन्यवाद.
Thank you so much, ma'am, for your valuable insights. Thank you, respected judges and speaker, for being with us today. Your thoughtful observation, experience, and word of encouragement have made this event meaningful and memorable for everyone involved. I will now invite Shri Vikrant and Goyal ji, General Secretary, Delhi Adhivakta Parishad, Delhi Prant, for vote of thanks.
Respected judges, esteemed guests, learned participants, and dear students, on behalf of Adhivakta Parishad Delhi Prant, it is my proud privilege to extend our heartfelt vote of thanks on successful conclusion of 4th National Moot Court Competition. We express our deepest gratitude to esteemed panel of judges, Honorable Mr. Justice Anil Kshetrapal, Judge Delhi High Court, Shri S.D. Sanjay, Learned ASG, Supreme Court of India, Dr. Balbir Singh, Senior Advocate, for graciously sparing their valuable time, sharing their profound legal wisdom, and providing insight observation that truly enrich this competition. Your guidance has been an inspiration for every participant. We sincerely thank all the participating teams from across the country. Your preparation, advocacy skills, and court etiquettes reflects true spirit of legal excellence and healthy competition. Each team deserves appreciation for the dedication, hard work displayed. Our special appreciation goes to the organizing team, faculty coordinators, volunteers, technical team whose tireless efforts ensured smooth conduct of the competition. Without your commitment, and coordination, this event would not have been possible. We also extend our gratitude to our office bearers, especially Shri Keshav Bhai Kotak, Patton, Shri D. Bharat Kumar ji, National General Secretary, Shri Hari Borikar ji, Organizing Secretary, Shrimati Seema Singh ji, Vice President, Shri Ashok Mehta ji, Shri Ranveer Kharkali ji, Shri Sanjay Poddar ji, President Delhi Prant, Shri Jivesh Tiwari ji, who was the ex-General Secretary and a very valuable asset to this organization. Their constant guidance and support. I thank the VCs and the professors of all the colleges and universities who are putting their best efforts on all the future young lawyers. Lastly, I like to thank everyone who joined us live and encourage the participants. We hope this competition has contributed meaningfully to the academic and practical growth of aspiring legal professions. With this, we conclude the competition on a note of pride and fulfillment, wishing all the participants great success in their legal future. Thank you. Jai Hind, Jai Bharat.
Thank you, Vikranji. Argue with law, listen with humility, and leave this courtroom stronger than you entered. May the learning from today guide your advocacy tomorrow. Thank you all for joining us today. Wishing you a pleasant day ahead. Jai Hind.